Case number 115038, State of Kansas v. Sims.
Good morning, Your Honor. My name is Randall Hodgkinson. I'm appearing today on behalf of Sheriff Sims. I request 3 minutes for rebuttal, please.
3 minutes is Randall.
Your Honor, this is a criminal case out of Wyandotte County. The facts in this case, it's a first-degree murder prosecution arising from an incident where some of the facts aren't largely disputed. The situation was where my client was at the decedent's home, and in fact, I think fairly uncontested that it was a fairly normal social kind of gathering. Very disputed facts then about circumstances that happened, and then again, undisputed facts that my client shot and killed the decedent in this case. So this case went to a jury trial where there's no dispute about whether my client killed the decedent, but there was substantial dispute about my client's state of mind in that incident. So we raised 3 issues in this case, Your Honor. I kind of plan to talk to you mostly about the second issue, had to do with instructions, especially as it relates to state of mind in this case and potential defenses, which might be sort of an odd pick on my part because there's a case right against me on it, and that may be an odd way to decide to argue, but I guess I chose that, 1, because it's critical to my client's case, and 2, because I don't get that many opportunities to re-argue cases from 12 years ago and try again. That's maybe my philosophy. So the issue has to do with whether or not there's an improper ordering when instructing the jury on imperfect self-defense in this case. And the impediment to that argument is the court's decision in State v. Bell, which sort of held this idea that imperfect self-defense and premeditation are mutually exclusive. So the fact that he was convicted of premeditated murder makes it, I guess, irrelevant or anything like that, whether these other instructions were right or not. And so I just wanted to take a shot at explaining why I think that decision was wrong, respectfully. So the question...
It's a matter of logic, you mean?
To some extent. So I would start with the idea of can, for example, a person charged with, and even who did commit premeditated murder, act in self-defense. And so the scenario I would give to you is I'm in my house and I look outside the window and I see some guys with masks on and dark clothing carrying guns coming into my house. And I think to myself, I've got a gun upstairs in my drawer. I'm going to go upstairs, get my gun, I'm going to come back down here, and as these guys are coming in my house, I shoot them. Now, that's premeditated. I went upstairs, I planned, I took time, I got my gun, I brought it back down with the intent to use it. So I think that's premeditated. That's a premeditated act. Is it self-defense under Kansas law? I think clearly it is. And it can be. And I cited Cook for that proposition. I think this court thinks that can be self-defense too. So the change in the scenario then would be, I see a person walking up my sidewalk. I don't see a gun. I don't see a mask, but I have some reason to fear this person. Maybe I've had bad blood with this person in the past. And I think to myself, I'm going to go upstairs. I think he's coming in to kill me. And I'm going to go upstairs, get my gun, come back down, and use it when he's coming to my door. I would argue that's imperfect self-defense. That I had the honest belief that this person was coming in, but that under Kansas law, we would say it wasn't a reasonably, objectively reasonable determination on my part. But it could still be so. I premeditated it just as much as I did in the first scenario. Exactly as much. But one of the premises under which I was acting in self-defense maybe wasn't objectively reasonable. And so we would say, you don't get self-defense. But under Kansas law, the Kansas legislature has said that scenario is imperfect self-defense. It's a kind of voluntary manslaughter. So the problem is Bell says that those things are mutually exclusive. If I premeditated, I couldn't have been acting unreasonably, I guess. And, Your Honor, I would respectfully suggest, and I can't believe I'm arguing against Justice Allegrucci opinion, but I think Justice Allegrucci in that opinion conflated those ideas. It's not that Justice Allegrucci said that, imperfect self-defense is the absence of reason. That's not actually true. Imperfect self-defense is I'm acting maybe with a reason. In fact, it really is. I am acting with a reason. I have a subjective belief in the need for use of self-defense. It's just that one of the factual premises under which I'm acting isn't objectively reasonable. It's not that I'm acting without a reason or without reason. It's just that one of my premises is unreasonable, and therefore I don't get full self-defense. If that's true, if my logic is right, that's what's wrong with Bell. Bell conflates those ideas and makes it so that this idea of premeditation and imperfect self-defense are mutually exclusive. That's not true. Under these scenarios I'm talking about, it's not true. And so we would ask you to revisit Bell. And if you revisit Bell and don't sort of hold that as a matter of law, those things are mutually exclusive, then the instructional argument that we have is, I think, carries some water. The idea that the problem in this case then is the jury in this case is told, if you find this was a premeditated murder, premeditated killing, the jury's told, don't consider these other things unless you don't agree that it's a premeditated killing. And that's what this court in Graham and the Court of Appeals in Cribbs had said. That's it's causing the jury to not ever actually get to voluntary manslaughter, even though that's a potential claim in this
How would it then be instructed if we revisit Bell, as you suggest, and maybe adopt some of your position here? How would the jury be instructed they would consider both those at the same time prior to moving on to, let's say, another lesser included? What would be done?
Yeah, I think there's a couple things. And I mean, you follow Graham. I mean, I would look at Graham for guidance on that question to the extent that the court said in Graham, you need to consider these things together. How exactly would you do it? I don't know that there's only one way, but one way might be what you just said. It might be that you give a different instruction, that you don't give voluntary manslaughter as a separate, like a separate instruction in that order, but somehow you give it separate outside of it all and say, as you consider all of these things, you should consider voluntary manslaughter. And if you have a reasonable doubt, then you have to go with that. So I think there are a couple different ways I can think of. That probably doesn't exhaust all those ways. The problem in this case is the jury was told, don't even consider these if you find it to be premeditated. But every person acting in self-defense and every person acting in imperfect self-defense will have committed a premeditated killing.
What do you think of this court's sort of gloss or clarification of Bell that came a year later in Lawrence, in which we said that we kind of addressed the argument you're making and said that the reason that they're mutually exclusive is because there's a difference in what's being thought over, in actually what's being premeditated. And I'm paraphrasing, but Lawrence effectively held that the justification for the Bell rule is that when you're premeditating first-degree murder, you're thinking over killing the person, whereas when you premeditate an act of self-defense, what you're premeditating is defending yourself. What do you think of that rationale for the Bell rule?
Your Honor, I haven't reviewed Lawrence because I don't think it was it cited in the state's brief?
That I'm not sure.
Yeah, I don't think it was because they didn't read the state's brief this morning. I don't think it was, but I believe what you've told me about it, and it doesn't change anything about my argument. I mean, the point isn't. I still think it's still conflating those things, because it's not the idea of premeditation is did I, in the examples that I gave, for example, is still did I plan to go kill that person? In both of the examples that I gave, and the answer is yes.
Well, Lawrence just draws the distinction and says that that's not actually what's going on. When you raise an imperfect self-defense claim, what you're actually claiming is that you intended to defend yourself as opposed to intended to kill the person.
By killing them. I mean, that would be a difference with no. That would be a distinction with no difference if that's what it says, Your Honor.
You just think Lawrence is wrong also. I'm sorry.
By using deadly force.
Yeah.
Because that's all we're talking about is deadly force.
That's all we're talking about.
Are you saying that if you intend to defend yourself with deadly force, that's the equivalent of intending to kill the person?
Yes.
Okay.
And so, to the extent that that's what Lawrence says, it would be the same argument, that it's conflating those things improperly. The question of premeditation is, did I think over ahead of time that I wanted to kill this person? And if I go upstairs and get a gun and bring it back downstairs, with the intent to use it, the answer to that's yes.
I think what you're saying isn't that they're, as a matter of logic, that they're conflating two concepts, two separate concepts, but that in fact they're failing to recognize they're the same. Because you're saying that intending to defend yourself with deadly force is the same thing as intending to kill somebody. If that's what you're premeditating the same thing. We may call them by different names, but
Yeah.
they're the same thing.
Maybe. I'm saying to the extent that the court is saying that they're mutually exclusive on the idea that that imperfect self-defense is the absence of reason. The question isn't whether a person acting in imperfect self-defense is using reason.
Right.
They're just, one of their premises is unreasonable. That doesn't mean they're not using reason.
Mm-hmm.
And that's where I think it's being conflated.
Okay. Got it. Thank you.
Your Honor, that's the only oral presentation I had this morning.
Any more questions? Thank you, Counsel.
Thank you.
May it please the court, Your Honors. I think the central issue here is the question of ordering. What Graham found, and the reason Graham exists, is because without the element of premeditation, there is no element difference between second-degree intentional murder, voluntary manslaughter, and voluntary manslaughter, other than additional factors present in voluntary manslaughter. And that's why the ordering becomes important. I highly disagree with appellate counsel that there is no difference in that premeditation and imperfect self-defense are not mutually exclusive. This court has made it clear that premeditation is different than intent. Premeditation requires a plan to actually kill someone. It requires a plan and steps to commit a murder.
It doesn't. It doesn't require a plan. We've said that. It doesn't require a plan or a scheme. It just it requires that they have thought the matter over beforehand and not instantaneous. That's
right.
What premeditation is.
But it still holds a difference between that and intent. Premeditation requires thinking about over or beforehand the murder. It requires something distinct from just intending to kill your target. And I think that's why it's different than self-defense, where self-defense requires an intent that one defend oneself. It's conditional. If one's life isn't in imminent danger, one doesn't take the action. And I think and I cite this a bunch in my brief, but...
And defend themselves with deadly force.
Right.
How can you intend to defend yourself with deadly force without having the at least implied intent to kill? If you use deadly force against a person, you intend the natural consequences. If you shoot someone in the chest, you're not going to be able to defend by saying, I just wanted to wound him and stop him. You're as a prosecutor going to say, no, that's intent to kill. And so I don't understand how they aren't the same.
I don't believe they're the same because one is conditional and one is not. I intend to premeditate a murder when I plan the murder or plan the action that's going to murder someone. Self-defense is conditional upon the imminence of a threat of bodily harm, and I talk about this a lot. The difference is imminence. The law requires even the mistaken belief that the force be imminent. It requires the person to have a real belief of imminent bodily harm against them. And I believe that's one of the other reasons it's distinct from what the appellant is saying. What the appellant is trying to argue is essentially, I can have an unreasonable belief of non-imminent bodily harm, and that would still work, but that's not what the law requires. The law requires that my mistaken belief be of imminent bodily harm.
If somebody's coming through my front door, I pull out my gun, and when they break through the door, I intentionally, I go get my gun, I do the preparation plan, I'm planning, they come through the door, I double tap in the chest with the intent to kill that person so they don't shoot back. Haven't I committed premeditated murder?
No, you haven't. because your plan is based on a belief of,
What element of premeditated murder is missing?
I would say, the premeditated intent to commit murder. You're intending to defend yourself. And
That's not the
That's
intent
not
that's
the
at
element.
issue. It's intent to kill, not intent to commit murder.
well, I don't believe that it is an intent to kill. I mean, your intent is entirely
You don't believe
conditional.
that intent to kill is an element of premeditated murder?
Oh, no, I do. I don't
Yeah.
believe in the factual scenario that's been presented. The person with the gun has the intent to kill. They have a separate intent, which is an intent to defend themselves. It's entirely conditional. If the person stops at the door,
And the testimony is that the police officer came, what did you do? Well, I saw him coming and I went to get my gun because I intended to kill them if they crossed the front threshold of my house. And malice aforethought is no longer part of the elements of first degree murder, so I don't understand why I haven't fed into all the elements of premeditated murder. I get a pass because of self-defense, but that doesn't negate the existence of the elements of premeditated murder.
I still don't believe it's the same thing. I still believe the conditional element of the self-defense factual scenario, if the person walks up to the front door, rings the doorbell, and walks away, that changes the factual scenario. It's a conditional element. But if the person walks away and I think, wow, that person really scared me, I'm going to go kill them, I open my door and hit them when they're facing away on the sidewalk, it changes my intent from a conditional to suddenly an
Counsel,
absolute.
I'm trying to understand your argument. Is your argument that an individual who possesses a premeditated intent to defend himself or herself and the death of the assailant results, that's insufficient to have a conviction for premeditated first degree murder? And is that your argument, that if those facts were present and we were reviewing on sufficiency of the evidence, a jury just could not convict a person who had the premeditated intent to defend themselves is insufficient as a matter of law to sustain a conviction for premeditated first degree murder?
The jury would still be instructed to view that as whether it was reasonable, whether the person still...
Well, I understand that, but the question is about this mutually exclusive nature of these two crimes. And I think the gist of these questions has been, is there any fact scenario that could support both convictions, where the same facts would be sufficient to support either a first degree premeditated killing or an imperfect self-defense voluntary manslaughter conviction? Because if the fact could support either conviction, then they're not mutually exclusive. I mean, I think that's defense counsel's basic argument.
I have a hard time in the few minutes coming up with a fact scenario where I believe both would be present.
Why wouldn't it be present in the scenario described by your opposing counsel when he first stood up? Why aren't both potentially defensible jury verdicts? That person was either not guilty because of self-defense or guilty of premeditated murder, depending on whether they believed certain other aspects of the testimony or evidence. Why wouldn't either verdict be defensible?
I believe in the current scenario, the one where people are approaching my house with
Right,
guns.
they've got the masks on and they've got the guns, and it's pretty clear they're coming to break in and rob.
I have a hard time with a factual scenario like that, believing that it would be possible for a jury to return a verdict of guilty to murder and not self-defense. I mean, that's part of the problem, is we stack that factual scenario so heavily towards self-defense that it doesn't make sense that a jury would return any other verdict. It becomes sort of a strange hypothetical. We're asking a jury to return almost a ridiculous verdict.
What if the guy recognized the people behind the masks, never liked them? What if we've got that testimony? Never liked them, thought they ought to be wiped from the face of the earth.
And
Just
again,
had a golden opportunity to call it self-defense. What if that's the evidence?
And again, I think we go back to it still seems so weighted towards one direction that it's hard to play
That evidence, with that additional evidence that he always hated them and thought they ought to die?
Well,
If you had that evidence?
in the factual scenario where that's the case, typically to prosecute, you would need some additional evidence that the individual did not realistically believe that they were a threat. For instance, if you could show that what they were wearing instead of black masks and guns was hunting smocks, and that they had gone hunting with this individual before, you might be able to draw a distinction. But when we're talking about at night, black masks, they have openly brandishing firearms, the fact that he knew them and wanted them dead on a prior occasion still wouldn't change the fact that they're presenting an imminent threat of bodily harm in his own house. And I think we get to the point where we stack the deck so much in terms of this, like in order for us to get to a point where these are in contest, we stack the deck entirely towards self-defense.
What's wrong with that? Doesn't it still provide us a logical example that there is a possible scenario where your opposing counsel is correct?
I don't think so, because I just don't view that as a scenario in which any court, any reasonable jury, I mean, even with the immunity statute we have now, or to even make it to the jury, let alone that a court would uphold that on the sufficiency of the evidence. I mean, you've described a scenario in which almost no reasonable person could believe that that was a unlawful use of force. And so it becomes hard to imagine a scenario where we could still even try that case. I mean, we're describing almost the nightmare scenario of masked armed individuals coming to your home, where the law gives you a presumption of the use of deadly force anyways, and saying that, well, isn't it possible that a jury could find that that was still premeditated? And I simply don't believe so. I think it would be almost impossible to imagine a scenario where someone could say that wasn't a reasonable use of force as self-defense, unless there's some other piece of evidence that was presented to a jury to disprove the defendant's claim that that's the scenario that was presented itself. And in that case, we go back to, if there's some evidence that what the defendant said wasn't true, that these masked men were not coming to his house armed with guns, that they weren't wearing all black or something like that, we get back to the self-defense is purely conditional. I'm only going to use deadly force to the extent it defends myself against an imminent use of force, versus I'm planning to kill these guys, I invite them over to go hunting, they come over wearing typical hunting attire with hunting weapons, and I blow them away. And in that case, the jury is weighing two different stories, same as it always is, but they're mutually exclusive, what the jury believes. The jury either believes this person reasonably believed that there was fear, or they believe he is lying and that he did not reasonably believe there was fear. That
Mutually exclusive is not he said, she said.
Correct.
Mutually exclusive means, as a matter of law, the jury can't go either way. I mean, there's a legal barrier that would prevent a conviction on one count, but not on the other.
And I believe
so
that
it's not just a question of jury evaluating credibility and picking, right?
right. And I believe that's present with premeditation. Either
Is there anything other than Lawrence? I mean, because it strikes me you're asserting the rationale of the Lawrence decision, which is the only distinction here is what is being premeditated.
And I believe that is.
Is there anything else, or is that what you're resting your case on?
I don't believe that's a bad place to rest it. I believe.
Fair enough. I'm just
Yeah.
is that it? Is that
That
where
would-
you stand?
Yes, Your Honor.
Okay.
Do you have any further presentation?
I can briefly address the issue of the motion in limine. I believe there was some issue as to my brief talking about the fact that the primary information found in the motion in limine, the issue about why the murder took place, was not actually part of the original motion in limine, but it was objected to. The state didn't oppose the objection, the judge granted it. I'm not trying to now say that the court should consider that that evidence was non-objectionable. What I'm trying to say is that the admission of relevant evidence, even if every party at the trial court was mistaken, should not be a grounds for reversal because it can't prejudice the defendant if it's information that should have come in anyways. And that was my entire presentation on the motion and limine issue. Otherwise, I have nothing further, Your Honors.
Counsel, I know when the clerk read the docket, you stood in front of the bar and announced who you were and who you represent. But typically, we also ask counsel to do that once they step to the lectern because this is being broadcast over the internet and it's also being archived. So somebody later might want to see you argue and say, who is this individual? So although it's a little late, could you repeat that for us?
Yes, I'm Ethan Zivsigler, and I'm here on behalf of the Wyandotte County District Attorney's Office. Thank you, Your Honor.
Very well. Any more questions? Thank you, counsel.
Your Honor, I don't think I have anything in addition based on counsel's argument, unless the court has questions.
How would it apply here, given that to the facts of this case, or as I understand it, your client, Mr. Sims, was handed a gun and shot the victim in the face almost simultaneous with being handed the gun, and there was some indication that prior to that happening, that your client had the garage cleared of the children and other people, so they wouldn't be, presumably, so they wouldn't be witnesses to anything that occurred. How would it apply here, given the instruction, given the facts? I mean, is it appropriate to even consider this, or how would you apply it?
Sure. I'm thinking about this as far as whether it's factually appropriate.
Factually appropriate.
What is your
maybe,
question?
maybe that's part of the question.
Yeah, and so
the scenarios you were giving as an example of why it was improper to have the instructions in the sequence were not the example that we have here.
Absolutely.
Right. So.
So on the question whether it's factually appropriate, then first of all, I mean, you would view that in that light most favorable to Mr. Sims, I think, when you're deciding that. And that's certainly the frame of mind that I'm answering the question,
Right.
which is my client's testimony, which was that there was some sort of disagreement about money.
Right.
I think that really wasn't disputed, and that my client says he saw the decedent reaching into a pocket or something like that, and that he had prior knowledge that that person had a gun sometimes, things like that. So the question is, does that evidence, in a light most favorable to my client, make it factually appropriate to give the voluntary manslaughter instruction, which the judge did? Really, that question is that's water under the bridge, too.
Right.
The district judge found
right.
that's factually appropriate in this case. That was never really disputed by the state. And so I guess that's my best answer to your question, right. Justice, and in fact, really the biggest dispute in this case wasn't whether my client caused the death in this case. It's not disputed. What his state of mind is absolutely what he was having a jury trial about. And to the extent that this was misordered and misdirected in some way, it really goes to the heart of his case.
But you have the added burden of clearly erroneous standard, right? If
yes.
they had ordered it different, you have to convince us that it's likely the jury would have reached a different verdict.
I mean, first of all, I would cite to Graham, which found that misordering is clearly erroneous. Although, I mean, I understand every case is factually different. And so, but in this case then, what we do have is this real dispute between them. And I know this court took out the words real possibility, but has said we're going to change the test. So is there a real possibility that, I mean, the district judge in this case thought there was a real possibility that this could be an appropriate verdict. And I guess I would ask you not to second guess that. Thank you, Your Honor.
Before you sit down, could you tell us what you're asking us to do?
I'm asking you to reverse this conviction and remand this case for a new trial with correct instructions and correct evidentiary rulings.
All right. Any more questions? Thank you, counsel.
Thank you, Your Honor.
Thank you both for your arguments this morning. Clerk will take this matter under advisement.